Okay. Usually it takes a few minutes for distinguished representatives of states, national human rights institutions, and civil society organizations to join in our Zoom session. We are very pleased once again to welcome all the distinguished representatives of states, parties to the African Charter on Human and People's Rights, national human rights institutions, as well as the representatives of non-governmental organizations joining us for the 12th day of the 66th ordinary session of the African Commission on Human and People's Rights that we are holding for the very first time via Zoom. Today's agenda would be the same as the agenda we have for the 11th day, which is the consideration of the state report of Mauritius under Article 62 of the African Charter. So once again, I wish to welcome the representatives of Mauritius, the delegation of Mauritius. I do hope that we didn't make your weekend a very difficult weekend, putting you to do a lot of work. I'm sure, given the depth of the report that you have submitted and the details that you have at your disposal, the questions that we have asked wouldn't be that difficult for you to respond to. And I do hope that it hasn't taken your time off your family and a bit of rest for the weekend. So once again, a very warm welcome, and we look forward in the course of today to receive your responses to the various questions that have been raised by honorable members of the Commission. And we do hope that you would also address some of the issues that have been raised in relation to COVID-19, including the impact of COVID-19 on access to services, particularly non-COVID related health services, such as sexual and reproductive health services. So I wish to once again thank you for joining us today and give you the floor for you to present the responses to the questions. Thank you very much again.
Thank you, Chair. Honorable Chairperson of the African Commission on Human and People's Rights, Honorable Commissioners, Excellencies, distinguished delegates, ladies and gentlemen, a very good day to you all from Mauritius. I wish to extend the sincere apologies of Honorable Nando Boda, head of the delegation, who is unable to be with us at the start of this session. He's taken up with some urgent matters and will join us later on this afternoon. In the meantime, my colleague and myself will reply to your questions. We shall be replying to the questions submitted in advance, as well as those asked orally last Friday by the Honorable Commissioners. At the outset, Chairperson and Honorable Commissioners, we confirm that the preparation of the report was effected after wide consultations with all stakeholders through the National Mechanism for Reporting and Follow-up. Allow me to start with the questions put forward by Honorable Atem in respect of Article 1, recognition and implementation of rights, duties and freedoms under the Charter, incorporating the African Charter. It is a fact that the provisions of the African Charter have not been incorporated into a single piece of legislation. However, most of the articles of the Charter are already afforded constitutional or legal status under mainly Chapter 2 of the Constitution and in a wide array of enactments, such as the Abolition of Death Penalty Act, Combating of Trafficking in Persons Act, the Environment Protection Act, Equal Opportunities Act, and Workers' Rights Act. As regards status of signature or ratification of the human rights instruments, The Republic of the Mauritius has initiated the administrative process for signature of the protocol to the African Charter on Human and People's Rights on the Rights of Older Persons and the protocol to the African Charter on Human and People's Rights on the Rights of Persons with Disabilities in Africa. And the relevant documents will be deposited to the African Commission in the coming months. In respect of the protocol on amendments to the protocol on the Statute of the African Court of Justice and Human Rights, the Republic of Mauritius has ratified the protocol on the establishment of the African Court of Justice and Human Rights. However, we have signed neither the protocol on the Statute of the African Court of Justice and Human Rights, nor the protocol on amendments to the protocol on the Statute of the African Court of Justice and Human Rights. Mauritius is, at this point in time, not considering the signature of the protocol on amendments to the protocol on the Statute of the African Court of Justice and Human Rights. The Republic of Mauritius, being a small island developing state and a densely populated island with stretched limited resources, does not propose to ratify or does not propose to sign or ratify the African Union Convention for the Protection and Assistance of Internally Displaced Persons in Africa, Kampala Convention. It is to be noted that we do not have problems associated with internally displaced persons in its broader definition as is envisaged under Article 1K of the Kampala Convention. It is for the same constraints that though Mauritius has signed the OAU Convention governing the specific aspects of refugee problems in Africa, it is not intended for the time being to ratify this convention. We nevertheless adhere to the principle of non-refoulement and treat requests for refugee status or political asylum on a humanitarian case-to-case basis by facilitating their resettlement in a friendly country willing to grant them refugee status. In this respect, we work closely with the Office of the High Commissioner for Refugees. Moreover, we are in the process of developing a guideline to assist the different stakeholders in attending to requests from refugees and asylum seekers. As regards the African Charter on Democracy, Elections and Governance, the ratification of the Charter is under consideration. Consultations with relevant stakeholders will be held shortly. Mauritius at this stage is not in a position to ratify the 1990 International Convention on the Protection of the Rights of all Migrant Workers and Members of their Families. The main reason is that Mauritius is geographically small, is among the most densely populated island states. In addition, the country has limited resources and is unable to provide the core basic services that would be required to migrant workers and members of their families. Mauritius applies the essence of the convention in cases of disputes between migrant workers and their employer. Moreover, it is not proposed to accede to the International Convention of the Protection of All Persons from Enforced Disappearance, as we do not have any reported case of enforced disappearance in Mauritius. We wish to reassure the Commission that the state of Mauritius is fully aware of the importance of those human rights instruments, and we will keep monitoring our constraints and review our stand as and when the need arises. As regard Article 5, prohibition of torture and cruel, inhuman and degrading treatment, a question was asked about absolute prohibition of torture and sanctions. The prohibition of torture is already entrenched in the Constitution of Mauritius in Section 7. Section 78 of the Criminal Code criminalizes act of torture by public officials. There are numerous other provisions in the Criminal Code which would cover acts falling within the definition of torture. During sentencing, the court can take into consideration aggravating circumstances and inflict higher penalty accordingly. As of date, the Independent Police Complaints Commission has referred 4 cases of assault torture for prosecution of police officers before respective district courts. Out of these 4 cases, 1 case is on trial and 3 are awaiting date of trial. The National Preventive Mechanism Division, under the aegis of the National Human Rights Commission, is allocated sufficient human and financial resources to carry out their work effectively. We were asked about the status of the Police and Criminal Evidence Bill. A draft bill has been prepared, and the enactment of this legislation is still under consideration by the government. In conjunction, the government is also exploring other avenues, both by the enactment of legislation as well as administrative measures, in order to strike this balance between the rights of the individual and the powers of the police. In this respect, all police officers are provided with a copy of the Police Instruction Manual, which comprises guidelines on human rights and other procedures that are in line with the fundamental human rights principles and other international standards to which police officers have to adhere to in the exercise of their duties. Moreover, a module on human rights has been included in the training program of police officers. Police officers are issued with a booklet on code of ethics with a view to encouraging them to comply with professional ethical standards. CCTV surveillance cameras have been installed in all police stations to promote transparency and accountability. Status of the National Action Plan Against Trafficking in Persons 2019-2024. The newly elected government has decided to review the draft National Action Plan with assistance from the local offices of the UNODC and the IOM. A consultant will be enlisted shortly for this exercise. In the meantime, proactive measures have been taken to raise awareness on human trafficking amongst migrant workers. To this end, migrant workers coming to Mauritius are being provided with pamphlets, Know Your Rights, which is available in 6 different foreign languages. Measures are also taken to facilitate the tracking of child trafficking, child prostitution cases, as well as providing for social support and alternative skilling to victims of trafficking. The Brigade pour la Protection des Mineurs carries out operations in game houses, hotels, discotheques, and also investigate in suspected alleged cases of child trafficking and commercial sexual exploitation of children. A hotline is put at the disposal of the public to report cases of CSEC, inclusive of child trafficking and prostitution. Victims of child trafficking are provided with medical care and police medical examinations, as well as HIV testing and pregnancy tests. Psychosocial counseling and support are provided to victims and their families. A building has been identified to house victims of human trafficking. In respect of corporal punishment in all settings, it is to be noted that corporal punishment in all settings is being addressed in the forthcoming Children's Bill. The bill is at drafting stage and is expected to be introduced in the National Assembly in this current session. There has been delay in finalizing the draft bill in view of the general elections 2019 and lockdown of 3 months due to COVID-19. Specific data on redress ordered by courts that were actually provided to victims of human trafficking and torture or their families. It is to be noted, for the period 2018 to date, the police has identified 7 alleged cases of trafficking in persons, out of which 5 cases are still under investigation. 1 has been referred to the Office of the Director of Public Prosecutions for advice, and in 1 case, 1 accused has been convicted. Moreover, the Intermediate Court has convicted 1 person. There is 1 case coming for pro forma and another scheduled for trial in the coming months. Concerning redress for victims of human trafficking and torture, following conviction under the Combating of Trafficking in Person Act, the court may order the perpetrator to pay to the victim appropriate compensation. I have endeavored to reply to all the questions that were put to us by Honorable Atem. And I will now pass on to my colleague to reply in respect to the questions raised by Honorable Kaitsi. Thank you.
Good morning, Honorable Commissioners. So I will reply to the questions relating to women's rights. In In relation to the question concerning the National Women's Council Bill and the measures taken to achieve a de facto equality between men and women in political and public life, as at date, the National Women's Council Act, which was enacted in May 2016, has been operationalized by 10 to 15%. The challenges in operationalizing the new legislation are that there is limited capacity of human resources. Secondly, an aging of existing women's association already affiliated with the council. And finally, difficulties in regrouping young generation in pursuing the gender equality agenda. Now, in order to achieve equality between men and women in political and public life, the government is coming up during the course of this month with a gender equality bill. In the meantime, capacity building programs on leadership and communication skills are being carried out with a view to increasing participation of women in decision-making instances. Moving on to the issue of the removal of Article 242 of the Criminal Code, an interministerial high-level committee to address the scourge of gender-based violence has been set up under the chairmanship of the Prime Minister. The issue of deletion of Section 242 of the Criminal Code will be considered by the high-level committee in a holistic approach. As regards affordable legal aid to women who are victims of domestic violence and how to improve adjudication of domestic violence cases, it is to be recalled that legislation in Mauritius does not specifically distinguish between women and men in the provision of services. Furthermore, the Legal Aid and Legal Assistance Act was amended to increase the ceiling for monthly earnings of the applicant from 10,000 rupees, which is about $250, to 15,000 rupees, which is about $375, so that more persons are eligible to legal aid and legal assistance. The Ministry of Gender Equality and Family Welfare has retained the services of legal resource persons on a sessional basis to provide legal advice to victims of domestic violence. With regards to the application for court orders under the Protection from Domestic Violence Act and legal representation at court, these services are provided by the legal resource persons of the ministry and are free of charge to victims at the level of the Family Support Bureau of the Ministry of Gender Equality and Family Welfare. As regards other family issues such as divorce, alimony, amongst others, free legal advice is provided to the public by the Ministry of Gender Equality and Family Welfare. To date, from the period of July 2012 up to May 2020, there has been 1,116 legal counselling sessions which have been conducted. And in relation to the rural and urban areas divide, well, actually, in Mauritius, women coming from the rural and urban areas obtain the same facilities. And as will be stated later on, this divide is minimal in Mauritius. Now, one of the main challenges in the adjudicating of domestic violence cases, it has been noted that there has been a delay in the handling of such cases at the level of the court, and that is at times due to a difficulty in the service of summons or of a protection order upon the defendant or the perpetrator. So, as indicated previously, there is a high-level committee which has been set up to address the scourge of gender-based violence, and these issues are likely to be considered at the level of the committee. In relation to laws criminalizing gender-based violence, some of the main enactments criminalizing gender-based violence are as follows: the Criminal Code, the Protection from Domestic Violence Act, the Combating of Trafficking in Persons Act, and the Workers' Rights Act. Moving on to the articles 2 and 18, the rights of persons living with HIV/AIDS. Regarding the statistics of transmission from mother to child, in 2019, out of 77 babies born to HIV-positive mothers, there were 6 who were diagnosed with HIV. In 2018, out of 68 babies born to HIV-positive mothers, 3 were diagnosed with HIV. In 2017, out of 69 babies born to HIV-positive mothers, only 1 was diagnosed with HIV. And finally, in 2016, out of 80 babies born to HIV-positive mothers, 3 were diagnosed with HIV. Regarding the plans and programs and policies in place in relation to the elimination of transmission of HIV from mother to child, the HIV antenatal care surveillance is in place to ensure close monitoring of the HIV trend in the country. HIV prevention starts with awareness sessions targeting the adolescents, girls, and young adults in and out of school through the use of information, education, and communication materials. HIV testing and counselling in accordance with established protocol and the HIV/AIDS Act, condom distribution, pre-exposure prophylaxis, lifelong antiretroviral therapy, post-exposure prophylaxis for the newborn. Breastfeeding is not indicated and formula milk is provided free of charge till the newborn reaches the age of 2. As I was stating previously, the divide in relation to domestic violence in rural areas, the rural-urban divide in Mauritius is minimal. As such, the customary norms alluded to are nearly inexistent. No such cases have been reported nor detected. As regards laws that prohibits sexual harassment, the laws which prohibit sexual harassment are the Criminal Code, the Equal Opportunities Act, the Workers' Rights Act, and the Protection from Domestic Violence Act. The challenges that impede progress in the country's general gender equality agenda are as follows. The commitment of line ministries to implement gender-based programs has been uneven. The investment in both financial and human resources has been inadequate. There is, at national level, a lack of expertise or knowledge on gender issues. And finally, the engagement of non-state actors in adopting a gender perspective within their respective sectors have been limited. Coming on to the strategies to reorganize the structures and mechanisms the government has established to push forward this agenda. Now, the parent ministry proposes to come up with a new national gender policy. It also proposes to review the functioning of the National Steering Committee on Gender Mainstreaming, to come forward also with the setting of a gender technical working committee for the public sector that will act as a consultative forum for gender focal points to discuss progress, achievements, and challenges of implementing the sectorial gender policies and action plans and provide guidance on adherence to gender mainstreaming. And finally, the last proposal here is to set up 4 gender technical working groups for the private sector, media, academia, and civil society organizations to ensure that gender is mainstream in these respective sectors. The major stumbling blocks that have been encountered in the implementation of gender-related structural changes and policies would be provision of adequate financial and human resources, including technical know-how and capacity building. As regards the strategies in place to raise the female labor force participation rate to the male level in the country and women participation in micro, small, and medium enterprises, women are encouraged to move from the informal to formal sector through registration of their businesses so that they could benefit from all schemes, support facilities, and programs put at their disposal. In this respect, the Development Bank of Mauritius Limited will provide some 200 million rupees, that's about $5 million, for loans and at concessional rate of 0.5% per annum. The government has established the National Women Entrepreneur Council to provide support and assistance to both potential and existing women entrepreneurs in Mauritius. Moreover, in line with the 10-year master plan prepared, the Ministry of Industrial Development, SMEs and cooperatives has initiated various schemes to develop the right entrepreneurial traits and skills to meet the challenges in global markets, namely Internal Capability Development Scheme, the Technology and Innovation Scheme, the SME Marketing Support Scheme, the Inclusiveness and Integration Scheme, and finally the SME Utility Connection Assistance Scheme. Now moving on to the question on traditional harmful practices. In Mauritius, we do not have any traditional harmful practices. As regards maternal and infant mortality rate and their causes in the country, Mauritius has achieved the 2030 SDG targets related to child and maternal mortality. In 2019, for 1,000 live births, infant mortality rate was 14.5, whereas the maternal mortality ratio was 62 per 100,000 live births. Most infant deaths are due to congenital anomalies and diseases related to perinatal period, mainly respiratory distress of the newborn. As regards maternal mortality, it is mostly due to health-related complications. I will now address the additional questions which was raised by the Honourable Commissioner in relation to updated women participation, such as SCEs, judges, ambassadors, and permanent secretaries. An updated list would be as follows. In relation to members of the Assembly, it is 12 out of 70, that's about 17%. Puisne judge, 14 out of 19, that's 74%. Judge in bankruptcy, that's 1 out of 2, that's 50%. Ambassadors, 5 out of 18, representing 28%. Clerk of the National Assembly, there is 1 and she's a woman. Clerk of Rodrigues Regional Assembly, again, there's only 1 and that's 100%. SCE, Senior Chief Executive, there are 3 out of 8 were women. That's a participation of 38%, and permanent secretaries 19 out of 36, that's 53%. As regards the amendment to family planning laws in 2018 and the delay to give effect to measures and any proposal to review the law, the Mauritius Family Planning and Welfare Association Act of 2018 was passed in December of 2018 and was promulgated in June 2019. It repeals the Mauritius Family Planning and Welfare Association Act of 2005 and provides a more modern approach to sexual and reproductive health in line with international norms. Delay is due to the fact that the National Executive Committee has not yet been constituted. Regulations are currently being finalized to supplement the provisions of the Act in relation to the constitution of the National Executive Committee. As regards the impact of land seizure on women in relation to the recommendations of the Truth and Justice Commission, there is no specific reference that has been made in the recommendations in the report of the Truth and Justice Commission regarding the impact on women, and there is also no recommendation specifically for measures to address same. So all avenues taken to implement the recommendations of the report will benefit any aggrieved women. And those would be the reply for Honourable Commissioner Ict.
I shall now address the questions put to us by Honourable Maya Fadel regarding refugees, asylum seekers, and migrants. The question was asked about why the Congolese asylum seekers were detained. The Congolese nationals had in fact entered Mauritius as tourists and later on applied for Mauritius identity cards and Mauritius passports, producing the documents of Mauritian nationals as their parents, but who in fact were their accomplices. They were arrested by police and sentenced to imprisonment. When detained in prisons, they claimed that they were refugees and alerted the United Nations High Commissioner for Refugees. A UNHCR delegation thereafter came to Mauritius to facilitate their settlement in other countries with the concurrence of the Mauritian authorities. As regards the guideline for asylum seekers and refugees, it is to be noted that following a workshop held in May 2019, a draft guideline was submitted in August 2019 by the UNHCR for consideration. After consultation with all the relevant stakeholders, the draft document is being reviewed in line with the general institutional and operational setup in Mauritius. As regards the question pertaining to the positive impact of the brochure Know Your Rights, it is to be noted that the production of Know Your Rights pamphlet in 6 languages has had a positive impact on the situation of migrant workers. It has enabled them to be fully aware of the parameters under which they should work, the role and responsibility of their recruitment agent, as well as their employer. Moreover, it has also provided them with a list of contact numbers that they can have recourse to in case of various problems they may encounter during their stay in Mauritius. As regards the general situation of migrants in Mauritius, you may wish to know that as at January 2020, there were 45,602 valid works permit for 56,500 male and 8,554 female migrant workers working, among others, in economic activities such as manufacturing, including textiles, construction, trade, hotel and restaurant, and information and communication technology. Among the migrant workers, 26,216 were from Bangladesh, 10,799 from India, 4,340 from Madagascar, 1,674 from China, 1,106 from Sri Lanka, and a few from Nepal and other countries. Several measures are put in place to ensure the protection of migrant workers, starting from their recruitment. Companies have to abide to stringent conditions safeguarding the rights of the migrant workers prior to be allowed to employ him or her. These include, inter alia, that the company is incorporated and has a legal entity. The company has a valid lodging accommodation permit. The company and the migrant worker has a valid contract of employment in line with existing labor laws, duly vetted by the migrant unit of the Ministry of Labor, Human Resources, Development and Training. The migrant worker is provided with a return ticket that is traveling to and from Mauritius to enable the worker to return to home country after the required period of employment. The migrant worker should be aged between 20 and 60. The migrant unit ensures that terms and conditions of employment of migrant workers employed in Mauritius are not less favorable than those prescribed by law and to that of local counterpart, and that their rights are respected by employers. Furthermore, it has a complaint desk and takes immediate action to remedy any dispute reported. As at December 2019, the unit has dealt with some 666 complaints and an amount of 7,758,208 rupees was recovered on behalf of the migrant workers. Additionally, the Occupational Health and Safety Division ensures that the migrant workers are provided with proper living conditions. Employers are not allowed to retain passport of migrant workers. Any case of non-compliance is referred to the Commissioner of Police for appropriate action. Moreover, memoranda of understanding are signed between Mauritius and the sending countries to ensure that all the rights of migrant workers are respected from recruitment stage, during their stay, and return to their country. A question was asked as regards la protection des migrants en situation pouvant être considérée comme irrégulière. The migrant unit ascertains that all dues are paid to migrant workers prior to their departure and that they are provided with a return air ticket paid by the employer. Basic necessities, including food, are provided to irregular migrants prior to their repatriation. I will now go to the other question asked by Honorable Fadel. It's regarding statelessness. It is to be noted that Section 22 of the Constitution guarantees Mauritian citizenship to children born in Mauritius, provided that at least one of their parents is a Mauritian citizen. However, the statement made by the Distinguished Commissioner in respect of Article 5 of the Mauritius Citizenship Act is not accurate. Section 5.1 of the Mauritius Citizenship Act provides that the minister may cause any Commonwealth citizen being of full age and capacity to be registered as a citizen of Mauritius upon satisfying certain conditions under the said section or where it is in the public interest to do so, as provided under Section 5.3 of the Act. Amendments which have been brought in 2019 to the Immigration Act are in relation to Section 5.1c, which concerns the resident status of a person, and to Section 8, relating to prohibited immigrants. There were no specific amendment made in 2019 in relation to children born or found in Mauritius with a view to protect them from statelessness. We were also asked about les mesures prévues par l'État concernant les cas d'enfants trouvés ou nés des parents étrangers sur le sol mauricien pour les protéger contre la patrie. Section 222E of the Mauritius Citizenship Act provides for the following, I quote, "A newborn child found abandoned within Mauritius shall, unless the contrary is shown, be deemed to have been born from Mauritius," end of quote. Moreover, Section 6.2 of the Mauritius Citizenship Act provides for the minister may, in such special circumstances as he thinks fit, cause any minor to be registered as a citizen of Mauritius. These provisions are presently deemed sufficient to ensure that children born from non-citizen parents and abandoned children found in Mauritius are not stateless. It is also worth being pointed out that there is no record and neither any report of stateless child found in Mauritius to date. As regards the additional questions put to us orally by Honorable Fadel, she asked a question regarding the consideration of situation of Chaguasian people as internal displacement. We take note of the wider definition made by Honorable Commissioner Fadel regarding displaced person and its possible relevance to the Chaguasian population. We will reflect further with this perspective in mind. As regards Chagos Archipelago, why the state of Mauritius did not envisage la voie contentieuse. As commissioners would be aware, contentious proceedings can only be brought before the ICG if the states concerned have consented to its jurisdiction. The UK has argued on several occasions that by giving an advisory opinion on the legal consequences of the separation of the Chagos Archipelago from Mauritius in 1965, the ICG has allowed the circumvention of the principle that the court should not consider a bilateral dispute without the consent of both states concerned. This then clearly shows that the UK would have never agreed to contentious proceedings being brought before the ICG in respect of the illegal excision of the Chagos Archipelago from the territory of Mauritius. As regards deportation and repatriation of illegal immigrants, including resort bulk repatriation, it is to be noted that as regards deportation, there has been no cases of deportation of migrant workers for the period 2018 to date. Regarding repatriation of foreign workers, the number of workers repatriated are as follows. For 218, 384 workers. For 219, 379 workers. And for 2020 to date, 101 workers. The main reasons for their repatriation are, inter alia, they have overstayed in the country after the expiry date of their work and residence permit or tourist visa, and they were in breach of their contracts or labor laws, and their contracts have been terminated. In respect of migration policy overview and effectiveness since its implementation, it is to be noted that the Migration and Development Policy was developed in June 2018. The policy is guided by the Sustainable Development Goals, SDGs, and responds to the target 10.7, that is, facilitate orderly, safe, regular, and responsible migration and mobility of people, including through the implementation of planned and well-planned migration policies. The policy aims to formulate and forward a strategic vision and roadmap in relation to all facets of migration in Mauritius. It analyzes and deals with the complexity of migration in a broad perspective with a view to ensuring better sustainable living conditions through measures such as addressing unemployment, boosting investment, innovation, and prosperity. With the National Migration and Development Policy, all stakeholders, including ministries, departments, as well as NGOs, have been able to understand the concept of migration and development. A mechanism in the form of a national steering committee has been set up to address migration and development issues in a coordinated manner in collaboration with all stakeholders and the International Organization for Migration. Thirdly, migration and development issues are being constantly monitored by the steering committee and bottlenecks addressed effectively. Also, the holistic approach to migration and development has become a reality for the Republic of Mauritius. Thank you.
I will now tackle the questions of Honourable King regarding Article 9 of the in relation to the freedom of expression and access to information. Honourable Commissioners, I will start by referring to the status of the bill and also to the additional oral question relating to the model law, which has been prepared by the Commission. Mauritius has taken note of the model law on access to information in Africa. A law on access to information in Mauritius has to be homegrown and adapted to our local context and our local realities. There are far-reaching implications ranging from constitutional to public interest issues. Such a legislation requires a prior process of internal examination, taking into account the required resources, the impact on the working procedures of the public service, preservation of sensitive commercial information, and cost implications, among others. Once this exercise is completed, all stakeholders will most certainly be consulted prior to its introduction, to the bill's introduction into the National Assembly. Moving on to the measures in place in the absence of a national law on freedom of information, government has already taken a number of important measures to enhance transparency, accountability, and greater openness in our public administration. The Citizen Support Portal is an innovative internet platform accessible on the web, which enables any citizen to either register a complaint or a suggestion, or make a suggestion, or make a query online and follow up at any time. As from March 2017, the proceedings of the National Assembly are broadcasted live on television. This live broadcast has significantly raised the standard of parliamentary democracy in Mauritius and demonstrates the commitment of government to transparency and openness. Moreover, people have access to the media to express their views and have unrestricted exposure to different viewpoints. There is no official or unofficial censorship of the press. There is unrestricted access to the internet, which is widely used. There is at present more than 60 dailies, weeklies, fortnightlies, monthlies confounded, in addition to the several online publications. The press in Mauritius generally operates in a conducive environment free of violence or coercion, with journalists free to exercise their profession. Moreover, the audiovisual landscape consists of the National Radio and Televisions, the Mauritius Broadcasting Corporation, and equally private radios and web TVs. The media operators do, to a certain extent, self-regulate and co-regulate themselves. A few operators have their own internal code of conduct. Moreover, the state of Mauritius provides funding to the Media Trust to carry out its activities, including capacity building and training for all its affiliated members. This affords, to some extent, means of co-regulation. Moving on to laws limiting the right to freedom of expression and principal justifiable limitations, the recent amendments to Section 46 of the Ict Act, these have been brought about to prevent the transmission or reception of a message which is obscene, indecent, abusive, threatening, false or misleading, or which is likely to cause or causes annoyance, humiliation, inconvenience, distress, or anxiety to that person. The amendments to the Ict Act do not violate the right to freedom of expression and are in line with Section 12 of the Constitution. The state does have laws which limit the right to freedom of expression, but these laws do take into account the principle of justifiable limitations as provided in Section 12(2) of the Constitution. As regards internet shutdowns, in Mauritius, there are no specific legislation to prevent internet and social media such shutdowns. Moreover, there is no legislation to specifically empower a shutdown. The Information and Communication Technologies Authority may take action if it is felt that content on the internet or other information and communication services is harmful and illegal. This, however, relates to specific content and not an entire information and communication services. As regards defamation, defamation is still a criminal offence under Section 288 of the Criminal Code. And the last additional oral question was in relation to cases of arrest or detention against journalists and reporters, including their outcome. Now, for the period of January 2015 to date, which is 25th of July 2020, no case has been reported to the police, the Central CID department, resulting in the arrest, detention of journalists and reporters while they were on duty. Those would be the questions in relation to Honourable King.
I will now address the questions put by Honourable Maria Teresa Manuela under Article 6.7, Prisons, Conditions of Detention and Policing in Africa. The total number of prisons and prison population improved in Mauritius, including statistical information. We have 7 male prisons in Mauritius with a total maximum capacity of 3,017 detainees. As of June 2020, we had a total of 2,397 male detainees, out of which 1,480 detainees were on remand and 900 were convicted. We have 3 female prisons in Mauritius with a total maximum capacity of 192 detainees. As of June 2020, we had a total of 152 female detainees, out of which 121 detainees were on remand and 31 were convicted. As of June of 2020, in the Rodrigues prisons, we have 37 detainees, out of which 34, 16 convicted and 18 on remand are male and 3 on remand are female. As regards juveniles, they are detained at the Rehabilitation Youth Center, and as at end of June 2020, there were 11 boys and 17 girls in these centers in Mauritius and 11 boys in Rodrigues. Problem of overcrowding in prisons. Mauritius does not experience the problem of overcrowding in prisons and detention centers. We were also, nevertheless, alternatives to imprisonment to curb overcrowding. Though we do not have overcrowding in prisons and pre-retrial detention centers, there is the possibility for the court to issue a community service order in lieu of imprisonment. Types of meals served in prisons. Sample menus can be submitted if required. Veg and non-veg menus are provided. A typical non-vegetarian meal would consist of bread, rice, pulses, poultry, fish, egg, liver, and vegetables. It is to be noted that the Mauritius Prison Service is self-sufficient in eggs, chicken, and bread. Moreover, it produces 40% of its annual vegetable requirements. Statistical data on the number of detainees that have enrolled in the numeracy and literacy programs mentioned in our report, as well as how many detainees, if any, have completed the courses, are as follows. During the period June 2019 to June 2020, 207 detainees have enrolled in different programs, and 204 detainees have completed their courses as follows. Numeracy and literacy, number of detainees enrolled 125, including 12 females, and they've all completed. Primary school achievement certificate, 10 aged between 25 to 34 years old were enrolled and 9 completed. BSc course in business management with specialization in marketing, 2 were enrolled and 2 completed. As regard disbursement of funds and how each detainee receives, and how much each detainee receives per week, it is to be noted that since January 2012, we have the Detainee Enhanced Earning Scheme. As per the scheme, detainees are classified in 3 following categories, namely unskilled, semi-skilled, and skilled. The daily rate payable for each category is Mauritian rupees is as follows. Unskilled, the daily rate weeks only, 20 rupees, maximum weekly expenditure 65, and they come up with a saving of 35 rupees. Semi-skilled, 25, the daily rate weekdays 25, the maximum weekly expenditure 81 rupees, and the saving is for roughly 43 rupees. For skilled, the daily rate weekdays only 30 rupees, maximum weekly expenditure 97 rupees, and the saving 52 rupees 50 cents. Returns are submitted to the prison headquarters and in press section for perusal and submission to the finance section for disbursement. Requirements for institutions and civil society organizations to visit prisons and places of detention. The Prisons Department works in collaboration with stake and non-stake actors, including governmental organizations, religious bodies, NGOs, local authorities, and private enterprises to provide a comprehensive rehabilitation program. The National Preventive Mechanism under the National Human Rights Commission and members of the Board of Visitors established under the Reforms Institution Act carry out visits in prisons and submit reports for any remedial actions. NGOs willing to visit and provide support to detainees need to make an official request to the prison authority. Following police clearance, an agreement MOU is entered with the prison authority. Subsequently, the representatives of the NGOs are issued with access pass. They are required to give prior notice before visiting prisons and detention centers. As regards special treatment for vulnerable groups in prison, particularly women, pregnant women, and those with children, persons affected by HIV/AIDS, and people with disabilities, it is to be noted that special facilities are available for the vulnerable groups in prisons. Women detainees and their children are accommodated in an appropriate environment, which is conducive to a proper growth and development of their children. These children are allowed to stay with their mother up to the age of 5. Pregnant women are admitted in a special ward at a dedicated public hospital during the last stage of pregnancy so that they can deliver their babies. After delivery, the newly born is automatically taken care of by the pediatric department, and should the need arise, by the AIDS unit of the Ministry of Health and Wellness. Prisoners with disabilities are also provided with facilities depending on the nature of their disabilities. HIV services are available in prisons for the HIV positive detainees. As regards medical facilities and treatments available to prisoners living with HIV/AIDS, It is to be noted that the Prisons Department, in close collaboration with the Ministry of Health and Wellness, operates a medical clinic which provides all the necessary treatment and facilities, including antiretroviral drugs to prisoners living with HIV/AIDS. Such detainees are also followed by prison psychologists. HIV doctors, who are the HIV treatment prescribers, attend the prisons on a roster basis. They conduct 4 sessions per week, and the prisons are considered as HIV care delivery points. Methadone induction and methadone substitution therapy are accessible and available to detainees who inject drugs. HIV-positive detainees have access to all facilities provided to the people living with HIV outside the prisons. The HIV preventive package of measures in prison settings include HIV testing and counseling, pre-test and post-test at entry point, information, education and communication, initiation and patients' education on antiretroviral treatment according to the established national treatment protocol, HIV disease management and follow-up to prevent resistance to HIV treatment, viral load testing in prisons. HIV-positive detainees who need admission are referred to the hospitals whenever required. As regards the status of the review of the existing statutory framework with regard to juvenile offenders and the time frame for implementation, it is to be noted that the Children's Bill will repeal the Juvenile Offenders Act and make provision inter alia for the establishment of an age of criminal responsibility and the provision of diversionary measure. The jurisdiction of the Juvenile Court will be taken up by the criminal division of the Children's Court. It is expected that the Children's Bill will be introduced in the National Assembly during the current parliamentary session. As regard minimum age of criminal responsibility, the forthcoming Children's Bill will also cater for a minimum age of criminal responsibility. The bill will also provide for the procedure for dealing with a child under criminal responsibility when under criminal custody is suspected for having committed an offense. Measures taken to disseminate and integrate the directives contained in the guidelines on the conditions of arrest, police custody and pre-retrial detention in Africa, and the principles on decriminalization of petty offenses in Africa adopted by the Commission. It is to be noted that most of the directives contained in the guidelines on the conditions of arrest and pre-trial detention are integrated in the police procedures on arrest, safe custody of detainees, and pre-trial detention. The best practices in the guidelines are being considered therein for implementation. As regards the principle on decriminalization of petty offenses in Africa, we have yet to consider the matter. Human rights training for police officers. Human rights course is a core module in the police training curriculum, which all new recruits have to follow. Additionally, police officers attend regular seminars, workshops on human rights, both locally and internationally. Statistics on complaints disposed by the Ipcc since its establishment. Since the establishment of the Ipcc up to the 30th of June 2020, 1,638 complaints have been attended by the Ipcc, including 277 cases from the Police Complaints Division. Some 650 cases have been disposed of, while 288 cases are still under investigation. Moreover, 29 cases have been settled through conciliation. Percentage of female police officers within the police service and measures put in place to ensure that women have equal opportunities. There are 1,152 female police officers in the Mauritius Police Force. They represent 10% of the workforce police, which is 12,870. Women police officers are treated equally and given the same opportunity as their male counterparts in the police force. Prosecutors, investigators, and station managers, commanders, among others. Their salaries and conditions of service are similar to male police officers. Nowadays, we have female police officers acting as riders, dog handlers, police prosecutors, investigators, and station managers and commanders, among others. It is to be noted that there is no discrimination in employment opportunity in line with the Constitution and the Equal Opportunity Act recruitment. Recruitment is done on a meritocracy. Ratio of police officers to detainees, ratio of police officers to population agents to detainees. As regards the ratio of population, it's 1 to 26. Since I'm being told to be pressed, I will submit the other questions in writing. We'll forward the questions in writing and go now to the questions put forward by Honorable Gertrude Alexia, Amherstbury, Seychelles.
Yeah, as you do that, interpreters are requesting if you slow a little bit down.
I was told I had 30 minutes, so that's why I was pressing. Is that,
no, for purpose of the interpreters,
Okay.
since they don't have the document, it would be good if you read as slow as you can.
Okay.
Yeah.
Okay.
Thank you.
I will now go I will now reply to questions pertaining to Honorable Alexia Amherstbury under Article 218. Indigenous people. The Constitution of Mauritius guarantees the fundamental rights of all citizens without discrimination. Our motto is one people and one nation. There are adequate legislative and administrative frameworks to ensure non-discrimination. We do not have any indigenous population in Mauritius. Mauritius is a country of settlement of peoples from Asia, Africa, and Europe. We have a diverse social fabric, and every citizen is constitutionally guaranteed the freedom to practice its own religion and follow its ancestral culture and beliefs. No study is therefore currently envisaged. As regards rights of persons living with HIV, according to Section 181B of the Immigration Act, persons who are inflicted with an infectious or contagious disease are considered as prohibited immigrants and are not admitted to Mauritius. However, provision exists under Section 8(2) and 3 of the Immigration Act. Provisions exist under Section 8(2) and 3 of the Immigration Act, which provides for the Prime Minister to authorize the admission to Mauritius of a non-citizen suffering from any infectious and contagious disease under certain conditions that he deems appropriate. There are various examples of cases where non-citizens afflicted with infectious and contagious disease have been allowed entry to Mauritius. These cases are related to applications from non-citizens, including those from the African continent, for work permit and occupation permit, as well as from dependents of occupation permit holders and foreign students. Additionally, non-Mauritian citizens who are HIV positives traveling to Mauritius for a short period are allowed to stay with a tourist visa. Furthermore, the HIV and AIDS Act was amended in 2008 to allow Mauritian citizens to get married to an HIV positive non-Mauritian, provided that he discloses to his intending spouse whether or not he is HIV positive or has AIDS. As regards the treatment, antiretroviral treatment, the Treat All World Health Organization recommendation has been implemented since August 2017. There is no discrimination in provision of HIV treatment to detainees. All individuals tested HIV positive are initiated on antiretroviral treatment, irrespective of their immune status. The detainee population is not static, but dynamic. As at end December 2019, there were 74% of the HIV positive detainees receiving HIV medication. In April 2020, this figure increased to 78%. The proportion of detainees not on ART is due mainly to the following reasons. Their baseline blood investigations, which are needed for choice of ART, is being awaited. They are still in denial phase of their HIV status, and they are not willing to start the treatment. They are waiting bail out incessantly and thus deferring ART. ART is being deferred to prevent HIV drug resistance in view of detainees indulging in unsafe behaviors, active injecting drug use and/or other addiction, and they are on treatment for other infections which need to be treated first to prevent drug toxicity and increase in mortality due to immune reconstitution inflammatory syndrome. Measures taken by government and prison authorities to prevent transmission of AIDS in prisons. The HIV preventive package of measures in prison settings include HIV testing and counseling, pre-test and post-test at entry point, information, education and communication, initiation and patients' education on antiretroviral treatment according to the established national treatment protocol, HIV disease management and follow-up to prevent resistance to HIV treatment, viral load testing. There's a good referral system to ensure a multidisciplinary approach to prevent AIDS-related complications in prisons. HIV-positive detainees who need admission are referred to the hospitals whenever required. As regards the report, the 2018 report, Commission of Inquiry report on drug trafficking, government has set up the following administrative framework to ensure effective implementation of the different recommendations found in the Commission of Inquiry report 2018 on drug and illicit trafficking. A high-level drug and HIV council has been set up under the chair of the Prime Minister to oversee and monitor the drugs and HIV response in the country. A national drug secretariat has been set up in 2018 under the Prime Minister's office to ensure the overall coordination at national level with regard to the implementation of the NDCMP as well as the recommendations of the Commission of Inquiry report. 4 subcommittees have been set up, namely Drug Prevention Committee, Harm Reduction Committee, Treatment and Rehabilitation Committee, and Supply Reduction Committee. A task force chaired by the Director General of the Independent Commission Against Corruption was set up to coordinate the implementation of the recommendations of the Commission of Inquiry and its annexes in relation to further inquiries that the Commission has earnestly called for in a number of identified areas and where the Commission has drawn attention to, but has not been able to gather sufficient evidence to investigate into. As at date, the task force has submitted 4 reports. An agreement has been signed between the National Drug Secretariat and the Mauritius Broadcasting Corporation to conduct a national awareness campaign against drug abuse on radio and television channels of the NDC. Additionally, a special committee will be set up to coordinate and ensure the follow-up implementation of the numerous legislative amendments required for implementations of the recommendations of the Commission of Inquiry. We wish to highlight that after in-depth analysis that some of the recommendations found within the report are not considered feasible and will not be implemented. It is to be noted that various enforcement actions are carried out in parallel to track drug and illicit trafficking of drugs. In this context, there is an effective coordination by the Police Department, Coast Guards, the Mauritius Revenue Authority and Customs, and all stakeholders, both at national, regional, and international levels. There have been, since 2017, a sharp increase in number of drug seizures. In 2019, the street value of drugs seized amounted to approximately 2.6 billion rupees. Moreover, there is a legal framework under the Good Governance and Integrity Reporting Act to enable the detection of unexplained wealth and its confiscation. As regards reconciling the usage of drugs and legislations pertaining to drugs, usage of syringes and the Drug Act, the legal framework for the syringe and needle exchange is to be found in the HIV and AIDS Act, and this act expressly provides for the syringe and needle exchange program. Section 16 of the HIV and AIDS Act specifically provides that when it comes to possession of syringes and needles, a person who is in possession of a syringe or needle in compliance with the HIV and AIDS Act shall not, by reason only of that possession, be considered as having committed an offense under the Dangerous Drugs Act. I now answer to the additional questions put orally in respect of follow-up treatments of HIV detainees once they leave prison. It is to be noted that all detainees undergo HIV testing and counseling at entering prison. Released detainees with HIV are issued with a discharge ticket, which they are advised to produce at AIDS unit in their respective locality for follow-up. Medical staff at the Mauritius Prison Service constantly share information with the AIDS unit regarding the discharged patient. The AIDS unit assures that the patient receives his or her treatment regularly. Moreover, there is a close collaboration between the social workers, NGOs, prison officers, and AIDS unit to follow up on HIV patients. As regards statistics of the population of Rodrigues and Outer Island as at 31st December 2019, there were 43,538 inhabitants in Rodrigues and 274 inhabitants in Agariga and Saint-Brando. Thank you. I will now reply to the questions put by Honorable Marie-Louise Abamo in respect of older persons and persons with disabilities. Non-inclusion d'un état des lieux des statistiques désagréées sur les personnes handicapées et les personnes âgées dans le rapport. Since the report covered period 2016 and 2019, and Statistics Mauritius conducted its last report census in 2011, we did not deem it fit to include same in the report. Statistics compiled at the level of the parent ministry as at end of June for social benefits are as follows. There are 232,602 elderly persons drawing retirement pensions, out of which 226,071 are aged between 60 and 81, 4,371 are aged between 90 and 99, and 160 age over 100 years. Moreover, 16,889 of them are severely disabled and draw a carer's allowance, and 35,276 elderly persons are also paid an income support. The number of persons in receipt of the basic invalidity pension as at end of June 2020 is 33,449, out of which 7,319 persons are severely disabled and draw a carer's allowance. The stumbling blocks for the adoption of a disability bill. The reasons were asked. The disability bill is still under preparation, and there are a few issues that still need to be addressed. There is need to bring amendments to sections 3 and 16 of the Constitution, which relate to the fundamental rights and freedoms of the individual and protection from discrimination, respectively. Moreover, the bill also needs to be aligned with the provisions of the UN Convention on the Rights of Persons with Disabilities. The bill can only be enacted and provisions made thereunder be implemented in a progressive manner when the necessary conditions and environment are created for the protection of the rights of persons with disabilities. Otherwise, the state would be held responsible for any incident happening to persons with disabilities. Although the bill has not yet been passed, it is to be noted, though, that several actions have already been initiated and upstream for creating enabling environment for the persons with disabilities. There are presently a series of legislations catering for the promotion and protection of the rights of persons with disabilities and for the eliminations of discriminations against them. We can provide the Commission same if required. As regard, we cannot therefore, as in view of the reasons mentioned above, we cannot provide an exact timing for the eventual enactment of the disability bill. As regards incentives, as regards guarantees put in place to ensure that disabled and persons and elderly are not discriminated, it is to be noted that there are a set of eligibility criteria and incentives to ensure that elderly persons and persons with disabilities who are eligible to services and benefits given by government are not being discriminated. In cases where persons with disabilities and elderly persons feel aggrieved or discriminated upon, they can have recourse to the appeal tribunal or medical tribunal established under the National Pensions Act. We were asked questions as whether non-Mauritian citizens benefit from this pensions, benefit from the same facilities. It is to be noted that every Mauritian citizen aged 60 and over is entitled to a basic retirement pension. The person should have resided in Mauritius for an aggregate period of 12 years since attaining the age of 18. For non-citizens, they should have resided in Mauritius for at least 15 years in aggregate since attaining the age of 40. 3 of those 15 years being immediately before the claim is made. A Mauritian citizen under 60 years who is certified by a medical board to be incapacitated to a degree of at least 60% or for a period of at least 12 months is eligible to obtain a basic invalid pension. For a non-citizen to be eligible, he or she must have resided in Mauritius for at least 5 years in aggregate in the 10 years immediately before the claim, one of those 5 years being immediately before the claim. As regards the reservations in respect of Articles 9(2)d, 11, 22b of the Convention of the UN Convention in respect of rights of handicapped persons, it is to be noted that the Republic of Mauritius proposes to withdraw its reservation on Articles 9(2)d and 11 of the UN Convention on the Rights of Persons with Disabilities shortly. The last reservation concerns Article 24.2b, which relates to access to an inclusive, quality and free primary education and secondary education on all equal basis for persons with disabilities. It is to be noted that Mauritius has currently a parallel system with regards to education of children with disabilities. On the one hand, a string of special schools, and on the other, mainstream schools. Mauritius has officially adopted a policy of inclusive education, and we are taking a number of measures to gradually allow for the integration of children with disabilities in mainstream education. The reservation will be withdrawn once we've complied with the obligations. As regards whether we are willing to share our best practices, Mauritius is very keen to do so and to benchmark with other countries, and we welcome any requests from member states. In a not too distant past, representatives of the Kingdom of Lesotho and the Republic of Seychelles did visit Mauritius to learn about our model of social protection and social benefits. Thank you. Thank you.
Honourable Commissioners, I will now deal with the Article 4, Right to Life. Question put by Honourable Gaye. Challenges for the repeal of the constitutional provision which provides for the imposition of the death penalty. Now, in relation to those, Section 4 of the Constitution provides for the protection of the right to life, except in circumstances where there has been a pronouncement of a court of law. The need to abolish the death penalty under the Constitution has not been felt, as with the passing of the Abolition of Death Penalty Act in 1995, all death sentences imposed before the passing of the said act have been commuted to sentences of penal servitude for life, the Supreme Court may now inflict sentences of penal servitude for life or sentences for terms not exceeding 16 years. It is to be noted that amending Section 4 of the Constitution cannot be effected unless it is supported by the votes of not less than 3/4 of the members of the National Assembly. As regards information on the concrete measures that are put in place to improve prison conditions for those serving life imprisonment to prevent their premature death. Now, in addition to the provisions of round-the-clock medical care, since May 2017, psychological support is provided to all detainees, including those serving long sentences. Moreover, detainees are encouraged to engage themselves in constructive and recreational activities. The number of prisoners serving penal, who have been sentenced to penal servitude for life, well, as of now, there's only one male prisoner. Relating to the number of deaths if any, of prisoners in Mauritian prisons and the cause of the death, as from beginning 2020 to mid-July, there have been 9 cases of death in prisons, out of which 2 cases are reported as suicide. 5 natural deaths, and the cause of death for the remaining 2 cases are yet determined by the police. Ratification of the 2nd optional protocol to the International Covenant on Civil and Political Right. On this issue, though Mauritius has abolished the death penalty by way of an enactment of the Abolition of Death Penalty Act in 1995, we are not proposing to ratify the 2nd optional protocol, but more so a 3/4 majority, as I've just stated, is required in the National Assembly before an amendment of the Constitution is made in relation to such a right, and this is not a routine process. Relating to the information on the legal or policy measures adopted to prevent extrajudicial or arbitrary killings, there have been no cases of extrajudicial or arbitrary killings in Mauritius. We are concerned with a few cases of death in police custody and detention centres, and legal and administrative measures have already been put in place with a view to reducing the number of such deaths. In relation to the additional question, oral question, requiring an update on the case at La Bastille, and including the outcome, with regards to the case of Mr. Permes, we wish to appraise the Commission that the police inquiry is ongoing. So far, 11 prison officers have been arrested in the case of the death of the detainee, which occurred on the 5th of May 2020. These officers have all been released on bail, of whom 9 have been interdicted with effect from 11th of June 2020. The remaining 2 have retired on the ground of age on the 14th of May 2020. We will now move on to the questions of Honourable Lumbu.
Honourable Chairperson and distinguished commissioners, I'm very honored to join you at this join the panel at this point in time. If you will allow me, distinguished commissioners, may I reply to questions on Article 10 and 11. There were questions on la liberté d'association et de réunion, questions qui ont été posées par Honorable Rémi Lumbu, le vice-président. La question est relative à la ligne directrice sur la liberté d'association et de réunion adoptée par la Commission. If you'll allow me, I will answer this question in English. Distinguished Commissioner, the Republic of Mauritius is fully aware of the guidelines on freedom of association and assembly in Africa. The main provisions of the guidelines are already incorporated in the Constitution and various legislations, including the Employment Relations Act, the Registration of Association Act, National Women Council Act, National Women Entrepreneur Council Act, amongst others. Moreover, the various institutions emanating from the acts sensitize members of the public on the services provided by them. There was also the issue about demonstration of groups beyond 11 persons. The state is at this point in time not considering to amend the Public Gathering Act, be it to allow more than 12 persons to take part in any assembly without notification to the Commissioner of Police, or to remove the limit on the number of persons who may do so. There was a question about the Prevention of Terrorism Act. So let me confirm, distinguished commissioners, that the primary legislation aimed at combating terrorism in Mauritius is the Prevention of Terrorism Act. It has been drafted in a manner which is respectful of the rights enshrined in our constitution, which remains the supreme law of the land. Distinguished commissioners, several amendments have been made to the Prevention of Terrorism Act within the parameters allowed by the Constitution. The Act is in compliance with international and regional instruments relating to the combating of terrorism, including the principles and guidelines on human and people's rights while countering terrorism in Africa. There were some additional questions. So there was one about the law for the protection of human rights for defenders and activists, whether this is envisaged. May I confirm that the rights of the citizens of the Republic of Mauritius are guaranteed by the Constitution, Section 3 to 16. These provisions are safeguards and apply to all citizens, including human rights defenders and activists. We have taken good note of the comments made by the Vice Chairperson regarding laws which have been adopted by Burkina Faso, Ivory Coast, and Mali in relation to the protection of human rights defenders and activists. We will take cognizance of the content of these legislations and share same with all the relevant stakeholders here in Mauritius. There was a question on what are the other islands that constitute the Republic of Mauritius, stated in paragraph 1 of the State Report on Mauritius. So let me just tell you that this description at paragraph 1 of the report echoes the definition of Mauritius in section 111 of the Constitution of Mauritius and the definition of the state of Mauritius under the Interpretation and General Clauses Act. Moreover, owing to natural phenomena, new islands may come into existence and appear within the territory of the state of Mauritius. It is worth noting, distinguished commissioners, that Mauritius is surrounded by several small islands, islets in fact, and some of them are even administered in collaboration with the World Wildlife Foundation, such as l'île aux Aigrettes, so that we can preserve, and Round Island, we can preserve the ecosystem of these islets. Let me now refer to the questions which were put by Honorable Solomon Derso, the chairperson. So allow me to reply at one go to the questions put to us on the economic, social, and cultural rights, Articles 14 to 17, and thereafter on Articles 21 and 24. First of all is about regards to right to property, whether there was any enactment of the Acquisitive Prescription Act. Let me confirm that the Acquisitive Prescription Act, which came into force on the 1st of September 2019, provides for better safeguards regarding acquisitive prescriptions. There was an issue as regards to equitable protection of the matrimonial and inheritance law. Let me, distinguished commissioners, tell you that matrimonial and inheritance laws are mainly governed by the Mauritian Civil Code. In respect to inheritance law, the rights of the surviving spouse, be it man or woman, are protected in as much as the surviving spouse has the same share in the property of the deceased as a child, and the surviving spouse enjoys the right of usufruit over the matrimonial home. The spouses each retain the properties they acquire prior to the marriage, and even properties acquired during the marriage, but through inheritance. The share of the surviving spouse can, however, be reduced or suppressed by the will of the deceased. This does not apply to children who are protected heirs and whose shares cannot be reduced or suppressed unless they have been judicially debarred from the succession of the deceased, what we call l'indignité. Let me now come to matrimonial law. Distinguished commissioners, spouses are free to choose the matrimonial regime which will govern their marriage. In case the assets of the couple are likely to be compromised by the debts contracted by one of them, a change in the matrimonial regime may be sought by way of an application to the Supreme Court. This provision not only protects the other spouse, but also protects the property rights and the shares of the children of the marriage. The property rights of the spouses and the children are also protected in the following manner. First, the matrimonial home cannot be given as security to a money lending institution unless both spouses gave their consent to sale. Second, the spouses married under the legal community of goods and property may contract household debts. A debt contracted by one spouse renders the other spouse liable. However, the liability of the other spouse cannot be invoked where the household debts are in excess of the daily lifestyle of the couple. And third, a woman may freely take up a job without having to seek the prior consent of her husband, and the proceeds of her salary accrue to her personally. Let me address the issue of right to work. And there was a request for disaggregated data, males, females, and the youth on the unemployment rate in Mauritius. Distinguished commissioners, the unemployment rate in Mauritius as at the first quarter of 2020 is 6.9% for both sexes and 4.9% for male and 9.9% for female. As regards the youth, that is between the age of 16 and 24, the unemployment rate in Mauritius as the first quarter of 2020 is 23.4% for both sexes, 18.3% for the male, and 30.1% for the female. Let me now address the issue of entrepreneurship program targeting the youth. Distinguished commissioners, Mauritius has introduced in 2018 the SME employment scheme with the aim of instilling an entrepreneurial spirit in unemployed graduates, as well as supporting further development of the SMEs. The scheme also helps to address a number of existing challenges as regards to youth unemployment and the inability of the SMEs to recruit graduates. Employment under this scheme covers a period of 2 years and renewed after the first year upon satisfactory completion. A monthly stipend of about 350 USD based on attendance is being provided to each graduate during this period, while the employer will pay only the monthly traveling costs. It is to be noted that a first batch of 478 graduates in Mauritius and some 43 graduates were placed in different SMEs since October 2018. In budget speech 2019-2020, provision has been made to extend this scheme to diploma holders also, hence encouraging more youth to take entrepreneurship as a career option. Let me now turn to administrative, fiscal, or other policies or measures fostering youth entrepreneurship. The Government Program 2019 has laid emphasis on entrepreneurs given that they are the workforce of the future. To that end, digital entrepreneurship, innovation, and research and development are being promoted. Measures are being devised to support youth-led startups, and accordingly, appropriate courses on entrepreneurship are being dispensed at the university level. The Development Bank of Mauritius is proposing to scale up its Campus Entrepreneur Challenge, whereby it will finance the 10 best projects at a concessional rate of 0.5% per annum for an amount of around $13,000, that is $500,000 Mauritian rupees. Distinguished commissioners, let me now relate to labor or workers' union in Mauritius and their roles and the determination of the national minimum wages. The Employment Relations Act provides for the setting up and the registration of a trade union which shall be a body corporate. Section 29 of the Act provides for the right of every worker to be or not to be a member of a trade union, and Section 30 protects trade union of workers against acts of interferences. As at December 2018, 409 trade unions were registered with the Registrar of Association. Most of the trade unions are affiliated to federations and confederations of trade unions. At present, there are 34 federations and 10 confederations. The National Remuneration Board is responsible to make recommendations on terms and conditions of employment of workers employed in the private sector. The National Remuneration Board is established under Section 90 of the Employment Relations Act and is constituted of representatives of ministries, employers, and trade unions. The chairperson and vice chairperson of the board are public officers. Similarly, the National Wage Consultative Council, responsible for making recommendations to the national minimum wage, comprises representatives of ministries, employers, and trade unions. Let me now come to the issue of promulgation of the Workers' Rights Bill. The Workers' Rights Act 2019 has been proclaimed and came into operation except for one section, Section 126, subsection 7, subsection B of the Act. Article 16, there was a question as regards to right to health and ratio of physicians per 1,000 inhabitants. The ratio of physicians per 1,000 inhabitants was 2.6 in 2019. This is well above the level recommended by the World Health Organizations. Let me now, distinguished commissioners, address the issue of emergency response. The pre-hospital specialized emergency medical services, also known as SAMU, le service d'aide médicale d'urgence, is operational in Mauritius since December 1997. SAMU is equipped with 10 advanced cardiac resuscitation and life support ambulances for pre-hospital interventions, that is 2 in each of the 5 regional hospitals. Pre-hospital interventions are done according to the 5 catchment areas, each falling under the aegis of a regional hospital, and concern mainly vital emergencies, including road traffic accidents and trauma. Pre-hospital interventions by the SAMU team are done after screening of incoming call at the SAMU control room by trained paramedical staff and physicians on a round-the-clock 24-hour basis. Distinguished commissioners, the average intervention time for SAMU is 20 minutes. Let me now address the issue of avenues of redress. Free healthcare services are provided through a network of 143 primary healthcare institutions, 5 regional hospitals, 2 district hospitals, and 6 specialized hospitals. Complicated cases which cannot be managed locally are sent abroad for treatment at the expense of government. And such help from government and support can amount to $40,000 per patient. And it is to be noted that universal access to the free healthcare services are provided regardless of gender, age, disability, geographical location, social status, and ability to pay. There is no discrimination in accessing healthcare services in general, except for migrant workers and citizens of the Comoros Islands, covered by a memorandum of understanding. All foreign nationals are required to pay for services provided at public health institutions. Considerations is being given to exempt foreign nationals married to Mauritian citizens. Yes, avenues of redress are available to a person who has suffered discrimination. Let me now, distinguished commissioners, address the issue of right to economic, social, and cultural development, Article 22. The issue of poverty rate in Mauritius was raised. So let me just confirm that Mauritius does not have a national poverty line. However, on the basis of available data covered at the household budget surveys, a relative poverty line set at half median monthly household income per adult equivalent is used to assess the poverty situation in the country. Presently, it is estimated that approximately 10% of the households are in situation of poverty. What were the results of the Marshall Plan? That issue was raised. So let me just confirm that for the purpose of implementing the Marshall Plan against poverty, a Marshall Plan social contract was introduced in December 2016 as a point of entry for eligible households who are registered under the Social Register of Mauritius to benefit from various supports based on conditions that are laid out in the contract. The social contract was initially valid for a period of 1 year and have been subsequently extended to end of December 2020. As at date, there are 10,274 eligible households under the Social Register of Mauritius, representing a population of 41,361 beneficiaries who are benefiting from an income support under the monthly subsistence allowance scheme. With a view to assessing the impact of the Marshall Plan in the alleviation of poverty, the Social Integration Division is currently in the process of conducting a review of the profiling of the existing 10,274 households through a recertification exercise. This exercise will evaluate the progress made by households following personalized support offered to them via case management with elements of conditionality. The recertification process is being effected by way of a formal re-registration and is expected to be completed by the end of this year. Distinguished Commissioners, let me now relate to the Right to Education, Article 17. There was a question as regards to regulation of private actors in the education sector. The government of Mauritius encourages active participation of the private sector in the provision of education and training. It ensures systematically that the provision is regulated so as to operate within the defined norms and standards. The regulation of private activities in education is carried out by various agencies falling under the overarching responsibility of the parent ministry, and statutory bodies acting as regulators for the different subsectors have been established. Namely, let me first name the Early Childhood and Care Education Authority for private pre-primary schools. Second, the Private Secondary Education Authority for private secondary schools. Third, the Mauritius Qualification Authority for private, technical, and vocational training centers. And fourth, the Special Education Needs Authority for private special education needs schools. The Higher Education Commission is the regulatory body for higher education in the Republic of Mauritius. And the Quality Assurance Agency promotes, maintains, and enhances quality assurance of higher education in line with international standards through appropriate quality assurance mechanisms. Let me now, distinguished commissioners, address the issues relating to science, technology, engineering, and mathematics. The Ministry of Education, Tertiary Education, Science and Technology is specifically mandated to look into the subject of science and technology. Students at all levels are always encouraged to opt for science education, and the ministry is alive to the science, technology, engineering, and mathematics policy. There is no discrimination regarding gender in opting for science subjects. Both girls and boys have equal access to the primary and secondary schools, where a common curriculum is taught to all of them. The curriculum in primary and secondary schools deals with matters of science. The study of sciences is compulsory for all boys and girls up to the third year of secondary education, subsequent to which they are encouraged to opt for science education. And there is no discrimination in science, technology, engineering, and mathematics enrollment at secondary school level. At the higher education level, research is encouraged in science, technology, engineering, and mathematics. And to that end, a research fund has been created at the level of the Higher Education Commission. Moreover, the Rajiv Gandhi Science Center has, as the agency responsible for promoting STM sensitization, adopted strategies of popularizing science and technology as per its mandate to maximize awareness. To this end, distinguished commissioners, the center mainly organizes competitions, exhibitions, outreach programs, awareness programs targeting primary and secondary students and the public. Let me now address the issue of technical and vocational trainings offered in our system. The Mauritius Institute of Training and Development is the provider for public vocational education. It offers various technical programs to provide human resource training to meet the needs of the world of educational nature. Polytechnics are another set of institutions that serve to complement the provision of higher level technical education, what we call the middle professional educational level. It is active across 4 clusters, namely health services and nursing, engineering, ICT and emerging technologies, and tourism and hospitality. The Polytechnics adopts a future-focused orientation towards rebranding and modernizing high-level and high-quality technical education with a view to address skill gaps in the middle management and the supervisory level in Mauritius and the region. In addition to the MITD and the Polytechnics, there are about 350 private training institutions registered with the Mauritius Qualifications Authority, which offer training, mainly in management and information technology. Distinguished commissioners, let me now come to Article 21 as regards to right to freely dispose of wealth and natural resources. Scientific, legislative, administrative, and judicial measures have been taken by the government of Mauritius to curb the establishment of shell companies that deprive communities around the continent of their right to benefit from the exploitation of their natural resources. On the part of the question referring to Mauritius having served as a tax haven, distinguished commissioners, we wish to point out that Mauritius does not display any of the characteristics identified by the OECD of a tax haven. Mauritius is compliant with international norms and standards. Hence, it cannot be contended that Mauritius is a tax haven. Mauritius has been assigned an overall rating of compliant by the Global Forum on Transparency and Exchange of Information for Tax Purposes during the 2nd round of exchange of information and request reviews. The Global Forum has commended the efforts of Mauritius to expand its exchange of information networks. As regards the legislative, administrative, and judicial measures that the government of Mauritius has undertaken to curb the establishment of shell companies, may I bring to your kind attention that amendments have been brought to the Income Tax Act and the Financial Services Act so that companies benefiting from any tax incentives would have to meet the substantial activities requirements, which include, first, core income generating activities should be in or from Mauritius. Second, employ directly or indirectly a reasonable number of qualified persons to carry out the core activities. Third, to incur a minimum level of expenditure proportionate to its level of activities. Fourth, be managed and controlled from Mauritius. And fifth, be administered by a management company. Distinguished commissioners, in view of the above, so-called shell companies cannot benefit from any tax incentives in Mauritius. In fact, reforms were brought to the Mauritius tax systems by legislative changes through the Finance Act 2018 and the Finance Act 2019 to remove all features that may be considered as potentially harmful. A list of these reforms may be made available to you, distinguished commissioners, and they are also available on the website of the Mauritius Revenue Authority. Following these reforms, all our preferential tax regimes have been cleared by the OECD Forum on Harmful Tax Practices. The ACHPR is satisfied that Mauritius does not have any harmful features in its tax regimes, including in the reformed Freeport and banking regimes. The preferential tax regimes of Mauritius have also been assessed by the EU Code of Conduct Group, and the tax reforms that have recently been implemented are in line with the strategy of Mauritius to be recognized as a well-regulated, transparent, and compliant jurisdiction. Let me now move on to measures put in place to ensure adherence to best practices, such as ensuring Mauritians benefit of the exploitation of natural resources and conducting environmental impact assessments. Respected commissioners, as you are aware, in March 2012, the Republic of Mauritius and the Republic of the Seychelles signed 2 treaties confirming their sovereign rights and establishing a legal framework for the co-management of the joint area. The treaty stipulates that all revenue from the resources will be shared on a 50% basis. These bilateral treaties pave the way for the sustainable co-management of the joint zone, for the elaboration of an environmental code of practice, and a safety and security code for the future exploration and exploitation of the living as well as the non-living resources in accordance with international conventions. Distinguished Commissioner, the 2 states have so far adopted the following. First, a model petroleum agreement for the joint zone. This agreement shall be used as a basis for negotiations between private operators and the 2 states. It encompasses, inter alia, clauses on fiscal regime, account and audit, assets and insurance, protection of the environment also. It also contains a set of legally binding codes which prospective operators will have to comply with, and these include integration of clean technology and best practices, while adhering to a fully elaborated, transparent process for environmental and safety assessment and ensuring a precautionary approach. Second, a joint fiscal and taxation code. This code provides for the taxation of income generated from natural resources activities. Third, an offshore petroleum safety code for the safe, secure, and sustainable exploitation of the petroleum resources in the joint area. All operations shall be regulated by the international legal practices, including prevention and control of pollution. The purpose of this code is to ensure that offshore petroleum operations carried out in the zone will first maintain the integrity of the offshore installation, second, secure the safety of operational personnel, and third, protect the marine environment. We have also an environmental code of practice for the sustainable management of the natural resources. This code set out the mechanism for the environmental impact assessment. It provides inter alia for environmental mitigations, remediation, including compensation in the event of economic loss, incurred expenses, as well as property damage. Furthermore, there has been a ministerial declaration on the protection of the environment and the sustainable development of the joint management area. Distinguished commissioners, Mauritius and the Seychelles are the first 2 mid-ocean island countries to have successfully established and managed a joint maritime jurisdiction. Let me now, if you will allow me, distinguished commissioners, report on the Truth and Justice Commission addressing the issue of land. Following the Truth and Justice Commission report, a land research and monitoring unit has been set up under the aegis of the Ministry of Housing and Lands in July 2019. Furthermore, a special fund has been set up and provided with an amount of 50 million Mauritian rupees, about $1.25 million in budget 2020-2021. The Land Research and Monitoring Unit has taken possession of 355 files in June 2019. Out of these 355 cases, 46 cases have already been entered in court. Further investigation and action is required in the case of the remaining 309 cases. One of the other main recommendations of the Truth and Justice Commission was the setting up of a land division of the Supreme Court to expedite matters in relation to land dispute. Distinguished Commissioners, on the 14th of July 2020, Government has introduced into the National Assembly for the first reading the Courts Amendment Bill, which provides for the setting up of several new divisions within the Supreme Court, including a land division, which will be specialized in the resolution of land disputes and be able to hear and determine matters regarding ownership of land and property rights. Let me now move on, distinguished commissioners, to Article 24 relating to satisfactory environment. There was an issue as regards to fund earmarked to support most vulnerable communities. Government has made provision in this year's budget for 2 billion rupees, about 50 million USD, under the National Environment Fund for securing sustainable and all-inclusive development as follows. 1.2 billion, about $30 million, to construct drainage infrastructure in high-risk flood-prone areas across Mauritius and retreats. 250 million rupees for rehabilitation, protection, and management of beaches, lagoons, and coral reef programs. 1.2 billion, about 30 million USD for flood management programs, and 314 million landslide management program. We have also 207 million rupees for Clean Up Mauritius and embellishment programs, and 153 million for solid waste management program, 40 million for disaster risk reduction program, and 126 million for green economy. Let me now specifically come to the issue of loss of wetlands and mangroves and the measures taken, distinguished commissioners. The loss of wetlands is being addressed through different mechanisms. Destruction of wetland by development activities is not allowed under the Environmental Protection Act, except with an environmental impact assessment. Compensation mechanisms are in place in these exceptional circumstances. At present, under the environmental impact assessment process, only one case of wetland backfilling has been allowed under the condition that a new wetland be created on site to compensate for the loss. The Ramsar Committee is advising on this matter. Furthermore, Mauritius is in the process of developing a wetland bill, which will provide further protection to wetland areas, which will allow for better management and restoration of the sites of importance. The final draft of the bill is ready, and the relevant annexes will comprise of the description of different wetlands that exist in Mauritius, and it is in the final stage of development. Government has already taken firm commitment for the promulgation of the bill. There were some additional questions which were put to us, distinguished commissioners. One related to whether any amendment to the Human Rights Act is being envisaged to include economic, social, and cultural rights. May I enlighten you, distinguished commissioners, that the first generation rights, mainly civil and political rights, are already protected under Chapter 2 of the Constitution of Mauritius. Additionally, the provisions of the welfare state in Mauritius already afford to a large extent second generation rights, the rights to education, health, housing, social security, and the right to work. And third generation rights, that is the right to clean water, right to development, right to a clean environment to Mauritian citizens. The UN Committee on Economic, Social, and Cultural Rights, after examining the latest periodic report of Mauritius, and that was in April 2019, has recommended that the National Human Rights Commission be provided with an explicit mandate to protect and promote economic, social, and cultural rights. This recommendation requires prior consultation with all the relevant stakeholders. There was also another question as regards to requirements of the environmental impact assessment for extracting of industries. The Environment Protection Act does not specifically mention extractive industries in Mauritius in the list of undertakings requiring an environment impact assessment license, and there are currently no such activities being carried out in Mauritius. However, the ministry responsible for the subject matter of environment may, at a time, by regulation, first amend the 5th schedule to the Act to include extractive activities in the list of undertakings requiring an environmental impact assessment. And second, issue policy and environmental guidance or standards for any activity that may have an adverse effect on the environment. Distinguished commissioners, the state of Mauritius is committed to the protection and preservation of the environment and will ensure that all activities impacting on the environment are duly regulated. The state of Mauritius is currently working on a seabed minerals bill, which will provide for the registration of prospection and mining activities in respect of seabed minerals, and an offshore petroleum bill to provide for the management of petroleum activities within the offshore area of Mauritius. Let me now come finally to the reporting guidelines on Articles 21 and 24. Distinguished commissioners, we have taken good note of the guidelines issued by the African Commission on Human Rights and People's Rights on state reporting under Article 21 and 24. And we will ensure that they are duly adhered to in our next review. I hope I have answered all your queries. My delegation have done their best to enlighten you. Distinguished chairperson and distinguished delegates, let me have, if you will allow me, for a few minutes, I will make some closing remarks.
I will allow you to make the closing remarks once I give the chance to the country rapporteur to make some remarks as well. I wish to underscore that you have answered in great details and comprehensively what have been detailed and comprehensive questions that we have sent to you as well. So we thank you very much for that. Commissioner Hattam.
Bonjour, Monsieur le Président. Bonjour, Monsieur le Ministre, chers collègues et amis. Je tiens d'abord à remercier l'honorable délégation de la République de Maurice pour la coopération pleine et entière que nous avons eue bien avant cet exercice. Et donc, les contacts ont été permanents avec eux, même durant le week-end. Nos amis ont bien travaillé pour nous donc, faire cet excellent exposé de 2 heures. Donc, je me réjouis personnellement en tant que commissaire rapporteur pour cet excellent exercice. Et bon, les réponses qui ont été données, aussi bien pour les questions de mes collègues écrites et orales que les miennes, sont vraiment satisfaisantes. Bon, il n'en demeure pas moins que, comme toute œuvre humaine, rien n'est parfait et que j'ai relevé donc certaines réserves de Maurice, notamment sur les migrants, sur le protocole de Kampala ou bien donc sur d'autres instruments. Et j'espère que notre collaboration et nos contacts donc, continus vont améliorer ces choses-là. Je garde un souvenir impérissable de nos visites à Maurice l'année dernière. Et donc, Monsieur le Président, Maurice reviendra certainement vers la Commission, puisque le rapport de de la mission de promotion fait en août dernier est en cours d'élaboration et nous aurons encore le plaisir de revoir nos amis mauriciens pour de plus amples discussions sur les droits de l'homme. Encore une fois, merci. Je vous rends la parole, Monsieur le Président.
Thank you very much, Commissioner Hatem. May I now request the Minister to make concluding observations.
Honorable Desu, Chairperson of the African Commission on Human Rights and People's Rights, Honorable Commissioners, Excellencies, distinguished delegates, ladies and gentlemen, we would like to thank the rapporteur for Mauritius, whom we met here, for the excellent work done, the excellent interface, and also I would like to commend the delegation in Mauritius for having worked during the weekend, but for having had a response from you. So that is very, very encouraging, and thank you for that. Of course, we will address the specific remarks of our rapporteur, because I think that having been in Mauritius and understanding from our answers, he has come to understand some of the why we have some reservations. May I, Excellency, on behalf of the delegation of Mauritius and in my own name, I wish to express my heartfelt thanks to you, Chairperson, and members of the African Commission for the successful organization and conduct of this virtual 66th ordinary session, despite the hard-hitting challenges posed by the COVID-19 pandemic. My delegation is indeed grateful for the warm expression of friendship, goodwill, and support extended to my delegation by the Honorable Chairperson and of the Commission and the Honorable Commissioners during the presentation of the 9th and 10th Combined State Party Report, particularly with regard to the comprehensive picture of bold measures taken by the government to consolidate the human rights landscape in Mauritius. We take this exercise and our engagement with the Commission very seriously in our drive to continuously update and review our human rights policy for the benefit of our citizens. In this regard, I wish to commend all of you for your dedication in carrying out the important responsibility entrusted upon you. I further wish to extend my sincere appreciation for the kind words expressed in regard to the valuable contribution and good work carried out by Honorable Bernard Sequen, who recently completed his mandate after having served as member of the ACHPR with devotion. Honorable Chairperson, the 66th Ordinary Session of the African Commission on Human Rights, People's Rights is an important milestone for all of us. More so, it has afforded a bright opportunity for Mauritius, not only to assess progress achieved, but to share its experiences in terms of implementation of the provisions under the African Charter. Honorable Chairperson, we acknowledge that it has been an intensive journey since 2017, when we initiated consultations for the drafting of our combined report. It has indeed been a prolific exercise, and it is heartening to note the recognition of the Commission regarding our fruitful efforts to strengthen a culture of human rights in Mauritius. We have also taken good note of the observations and comments of the Honorable Commissioners, which we will endeavor to take on board. We will report to Cabinet on that and to the Prime Minister. I therefore reiterate my profound gratitude for the constructive deliberations we had with the Commission over the last 2 days. Allow me to avail this opportunity to refer to the status of submission of state reports, which was presented to us last Friday. We have noted that numerous state parties are not up to date with the submission of their state reports. In this respect, we feel that we should essentially reflect as to whether a derogation from Article 62 of the Charter is not warranted for an extension of the reporting period to assist state parties for a timely submission of the periodic state report. Coming back to Mauritius, Honorable Chairperson, the unprecedented COVID-19 pandemic has impacted on almost every sector in every country around the globe. The pandemic has led to unparalleled severe consequences and dramatic loss of human lives. Governments have had to have recourse to drastic measures in the fight against the virus, while at the same time safeguarding the rights of their citizens. Mauritius has also not been spared, and we have taken a series of measures to strengthen the level of preparedness and response to the pandemic threat by adopting a collective, coordinated, and comprehensive approach, engaging all stakeholders. Thanks to the cooperation of one and all, whereby the population abided by rigorous restrictions, we have been successful in breaking the chains of the COVID-19 transmission, and Mauritius today is COVID-free for local cases. Honorable Chairperson, I would like to place on record among the key economic responses to limit the human and economic impact of the COVID-19 pandemic. Our government took the decision to reduce its overall spending by 10%. Additionally, an initial financial support plan to the tune of almost $250 million was approved to mitigate the adverse impacts of the crisis. Appropriate support was extended to households and communities through the distribution of 35,000 food packs to vulnerable people and a special assistance plan to families having contracted a housing loan. Likewise, a COVID-19 Solidarity Fund was set up to relieve the most deprived citizens, and the President of the Republic and a number of parliamentarians pledged to contribute 10% of their salary for a year to that fund. Honorable Chairperson, the policies and actions of the government in Mauritius have always been guided by a human rights-based approach to the economic, social, and cultural development of the country, so as to enable our citizens to enjoy a good quality of life based on human dignity, equality of treatment, economic empowerment, and social justice. To that end, Mauritius has demonstrated its commitment to uphold the principles of human rights by putting in place various policy frameworks, measures, and institutions to ensure that the rights of each and every individual are respected. Honorable Chairperson, distinguished commissioners, Mauritius has over the years consolidated its democratic welfare state governed by the rule of law, which guarantees the fundamental rights and freedom of all citizens. Public expenditure amounting to 50% of the government annual budget go to the welfare state for the provision of free healthcare services, free education from pre-primary to the university, various social services, including financial aid and free transport to the vulnerable groups, is a testimony to the importance we attach to uplift the lower sections of the population. On many occasions, Mauritius has been loaded for an allocated government budget of $500 million USD to social security, which encompasses a number of initiatives relating to social protection of the elderly, persons with disabilities, widows, and orphans. Likewise, there is consensus that free education in Mauritius is paramount to poverty alleviation and gender and youth emancipation, while facilitating the transition into a modern, knowledge-based society. Achieving the objective of the universal health coverage is equally at the epicenter of the government agenda, and the pandemic was a major challenge. The government is firmly committed to provide free quality healthcare facilities to the population. Indeed, every citizen of the country can not only access community health services, but also avail of the most sophisticated medical treatment in public health institutions. Today, a landmark achievement of our welfare state is also access to free transport services to students of the primary, secondary, and tertiary educational institutions, to the elderly and disabled persons along all means of public transport, including the Metro Express, which is a light rail system. Honorable Chairperson, to end, I would like to say that our strong civil society is a hallmark of robust human rights system, as it stands to be an important partner in assisting the government to address the needs of citizens at grassroots level. In this regard, there is now closer collaboration between the public, private sectors, NGOs, and stakeholders to bring about effective human rights protection in Mauritius and to enhance public awareness about human rights. The civil society has a crucial role in acting as a watchdog and calling out instances of human rights violation while instilling a culture of integrity and an awareness of social and environmental justice in people. Honorable Chairperson, distinguished commissioners, finally, in conclusion, my delegation once again extends its appreciation to all for what we consider to have been a fruitful periodic review of Mauritius, and we will learn a lot from it. I hope that the additional information provided by my delegation today have answered the questions and observations of the respected commissioners. We would like also to extend our sincere thanks and appreciation to the administrative and logical staff who worked during the weekend, I have been told, who have all worked with dedication to make this virtual meeting a success, including the interpreters who facilitated our work. Finally, distinguished Chairperson, we wish to reaffirm our commitment to the values of the Africa Union and Mother Africa and its relentless efforts to bring unity, peace, and prosperity. Thank you.
Thank you so very much, Minister, to you and your delegation. We do not, at the African Commission, take the commitment of Mauritius for collaboration with the African Commission lightly. We very much take your commitment and your collaboration with the African Commission as a mark of your dedication to your obligations under the African Charter on Human and People's Rights. We therefore commend you tremendously for this exercise and for your reaffirmation of your commitment to the African Commission and the African Charter on Human and People's Rights. We consider, given the depth of information that you have provided, including in respect to the COVID-19 pandemic and its unprecedented socioeconomic and human impact, not only on Mauritius, but also on all countries across the continent and the world over, and the responses that Mauritius mobilized in that respect in order to limit the impact of COVID-19 on the enjoyment of human and people's rights in Mauritius. We take note of the fact that the welfare state of Mauritius must have contributed significantly for limiting the adverse consequences of the COVID-19 pandemic on Mauritius, including the provision of universal access to free health care, whose absence or weakness in many other parts of the continent have been one of the source of vulnerability for many of the countries on the continent. And we do consider the experience of Mauritius in this respect, not only in terms of universal access to healthcare, but also other areas, including social security, free education, free transport services, as examples that others can emulate in order to advance the forward progress towards realization of the ideals of the African Charter on Human and People's Rights, particularly as countries respond to COVID-19 and plan for a post-COVID-19 socioeconomic and political order that would enable Africa to achieve a much better, a fairer, just, and human conditions for the upliftment of the mass of the people from poverty and achieving a minimum standard of living in accord with human dignity. Once again, we thank you very much. As you plan to work on your bills, including a bill on seabed minerals, as well as offshore petrol bill, I wish to indicate to you that the state reporting guidelines and principles on Articles 21 and 24 of the Charter would provide you useful insights on the various considerations that you need to take into account in developing and finalizing those bills. Minister, to you and to your hardworking delegation, we once again express our full support and appreciation for a commendable work that you have done. We look forward to continue the dialogue, and I wish personally, and indeed I speak on behalf of the Commission in requesting at this point in time for Mauritius to be the champion of the African Commission on Human and People's Rights, for you to be our ambassador. It would be really an honor for us. As you said, good examples that we would like others to follow. Thank you very much once again.
Excellency, we have been very honored. I've been very honored to be with you these 2 days, and we look forward to seeing you in Mauritius, the borders opening. We would like you to come here and to experience the Mauritian touch. And of course, we would like to do better. And we'd like also with our brothers and sisters of Africa, share our experiences and share all a common future. Thank you so much.
Thank you very much, Minister. Colleagues, honorable members of the Commission, distinguished state representatives, NHRIs and civil society organizations, this brings us to the end of the consideration of the State Report of Mauritius. We have had a very fruitful and productive and candid exchange on the state of human rights in Mauritius, and we appreciate the participation of all during the course of Friday and today in reviewing this report. This being the end of the consideration of the State Report, we have one request before we come to the end of today's session for delivering a statement on agenda item 3. This is by the Arab Republic of Egypt. I wish to request the representative of the Arab Republic of Egypt to take the floor for delivering the statement of Egypt. We have the representative of the Arab Republic of Egypt, and we welcome the representative to take the floor and deliver this statement. Welcome, Ambassador.
Thank you, Mr. Chairperson. Mr. Chairperson, honorable commissioners, ladies and gentlemen, I would like at the outset to applaud ACHPR for holding this online session in light of the ongoing restrictions as a result of the COVID-19 pandemic, and to commend the dedication of this session to addressing the negative impacts of the pandemic on the enjoyment of human rights in Africa. The onset of the pandemic made it clear that the international community lacks resilience and readiness to deal with such crises. The world today is in a dire need for enhancing cooperation and solidarity, as well as rebuilding new innovative support systems and networks. Egypt believes that Africa should be a major contributor to the efforts of reshaping the international regime post-COVID-19 to make it a regime in which the economic, social, and cultural rights receive proper attention. All states agreed in the International Covenant on Economic, Social, and Cultural Rights to seek to achieve the full realization of the rights contained therein, progressively and based on their capacity, as well as international cooperation and solidarity. They represent what every individual wishes to enjoy in his or her life and for the well-being of their offspring. Civil and political rights are, for the most part, the means to secure the peaceful pursuit and realization of economic, social, and cultural rights, and to serve to ensure the free expression of grievances for lack of progress in attaining these rights. Unfortunately, the forest is often mistaken for the trees, and focus is often placed on the means rather than the actual end goals. COVID-19 once again proves that the whole world is on the same boat and provides us all with an opportunity that we should not miss to redirect its rudder, hence setting our priorities right. Bearing in mind that ensuring the provision of the highest attainable standard of physical and mental health is the primary responsibility of the state, and that it is up for each state to define its health policy in accordance with its national priorities, there are certain elements in this regard that are of particular importance for us in Africa, including the following. 1, guaranteeing access to medicine and treatment during these difficult times is a prerequisite for ensuring the sanitary safety of our populations. 2, that burden heavily weighs down on developing countries and undermines their ability to seek the realization of the right to development. 3, advancing food security agenda is essential to achieve internationally agreed development goals, including SDGs, particularly in relation to eradicating poverty and ending hunger and malnutrition. 4, the impact of COVID-19 on the environment signals the importance of promoting recovery efforts, including directing investment to building sustainable and inclusive economies, achieving affordable, reliable, and sustainable energy for all, reversing biodiversity loss, combating land degradation, desertification, deforestation, and drought, which all have their negative ramifications for the lives of millions in Africa and the enjoyment of their human rights. 5, special attention needs to be given to people living with HIV and AIDS who may contract COVID-19 in many parts of Africa, where more than 26 million people living with HIV exist. 6, it is crucial to step up efforts to curb the rising discrimination and xenophobia against people of African descent and migrant workers and their families in the host countries, even more so in the context of COVID-19, be it manifested in stigmatization, lowering working conditions and layoffs, increased restrictions on movement, forced returns, or otherwise. In light of the above, I would like to take this opportunity to reiterate the call officially made by Egypt in the 64th Ordinary Session, based on Article 45 of the African Charter on Human Rights, on Human and People's Rights, that ACHPR conducts a comprehensive study on the ways African states and peoples can benefit from scientific and technological advancements in line with Article 15 of the International Covenant on Economic, Social, and Cultural Rights, particularly now the right to the highest attainable standard of physical and mental health, and to assess the challenges and make recommendations. Mr. Chairperson, let me briefly inform of the progressive, precautionary, and preventive measures that the government of Egypt took in the wake of the COVID-19 global spread. A Supreme Committee was established to coordinate national efforts to control the spread of the virus in close coordination with WHO. In this regard, a number of hospitals were designated to quarantine positive cases in every single governorate, quadrupling the overall number of beds in intensive care units and providing them with ventilators, in addition to increasing the number of laboratories and boosting their capabilities. Statistical updates are announced daily by the government regarding the national spread of the virus. An amount of 1 billion Egyptian pounds is allocated to finance the COVID-19 response plan. Training is given to all doctors and medical workers helping in the fight against the virus, and they receive special financial benefits. All public service premises are fully disinfected several times a day. The exportation of legumes was restricted for 3 months to secure strategic reserve, and 6 months stock of staple food supplies are kept and are made available in markets and through fixed and mobile outlets and cooperatives. International flights were suspended for 4 months, and special charter flights were operated to bring back Egyptians stranded abroad, who were then subjected to quarantine upon arrival. A curfew was imposed throughout the country for almost 4 months. Attendance at schools and universities is suspended, with measures taken to ensuring continuing education online where possible. Measures are taken to limit the number of administrative workers at governmental authorities and agencies, the private and banking sectors, and the public business sectors. Working from home is encouraged when possible. Exceptional grants are dispersed via an automated system to workers at the informal sector. Natural gas prices are reduced. Electricity prices are reduced for industrial uses as well. Payment of real estate taxes are postponed for 3 months, and payments of arrears is allowed by installments over a period of 6 months. All administrative forfeitures on non-compliant taxpayers is foregone in return for paying 10% of the due tax and resettling their statuses with dispute settlement committees. Mr. Chairperson, Since the 65th ordinary session, several laws were enacted in Egypt, including the law on the protection of personal data and the law on the protection of the identity of victims of sexual violence and harassment, to mention only a few. The Supreme Standing Committee for Human Rights was launched in early 2020 as an intra-governmental body tasked inter alia to devise a national human rights strategy, to lead national efforts on human rights education and training, and to deal with regional and international human rights mechanisms, including ACHPR. There is a lot yet to be done, but with a keen sense of purpose, Egypt is determined to work for the realization of all human rights for all its citizens. Finally, in light of the deliberations that took place in the 64th ordinary session on Egypt's periodic report to the committee, the government of Egypt is hoping to receive the ACHPR recommendations as soon as possible in order to give them due consideration in the preparation of the national human rights strategy and to prepare for the next periodic report to the Commission. I thank you, Mr. Chairperson.
Thank you very much, Ambassador, for that statement of the Arab Republic of Egypt. We take note of the issues that you have raised in relation to the impact of COVID-19, including the priorities in respect of which attention needs to be paid as far as the response on the African continent is concerned, many of which actually are in conformity with and reflect the various statements that have been issued, as you know, by the African Commission on Human and People's Rights from the 28th of February until very recently, at a general level, addressing all areas of human rights, but also specific categories of thematic responsibilities through the various special mechanisms of the Commission. We also take note of your proposal in terms of the request for undertaking a study by the African Commission on Human and People's Rights. We will take this forward in the context, as you rightly said, particularly of the prominence that the high standard of physical and mental health had acquired in the context of COVID-19. And indeed, it would be one of the areas that the Commission in the course of this pandemic had highlighted as an area that requires more intervention and more investment in order to avoid the vulnerabilities and weaknesses of our societies. We also take note of the various measures that have been adopted at the level of Egypt in order to respond to and address the threat that COVID-19 poses to the right to health and to the right to life, as well as to mitigate the impact of COVID-19 on the socioeconomic well-being of Egyptians through various measures, including exceptional disbursement of exceptional grants, as well as the relief measures relating to natural gas, as well as industrial activities, as have been pointed out in your statement. We also take note of, Ambassador, your appropriate request relating to the recommendations of the concluding observations of the African Commission in relation to the state report of Egypt, which we have considered in Sharm el-Sheikh when you hosted us in 2019. So we will take all of these forward in terms of your observations regarding the role of civil and political rights, Ambassador. As you know, under the African Charter on Human and People's Rights, indeed, one of the genius of the African Charter on Human and People's Rights is the consideration that all generations of rights are equal and interdependent, and all of which basically, by their very nature, are meant to and draw from the dignity of all of us as human beings. And therefore, the equality and importance of all of them for achieving a higher standard of living, for achieving a dignified life, is something that the African Charter, including in its preamble, have underscored. And definitely it is one that we also underscore in order to ensure that the interdependence of these rights is maintained. Once again, thank you very much for the statement, Ambassador, and for your active participation, as usual, in the sessions of the African Commission on Human and People's Rights. We take note that this situation has been a very challenging situation for all of us in all our countries, indeed for our institution, the African Commission as well. But we also consider that this current challenge presents us an opportunity as Africa in order to address the various fragilities and weaknesses that have allowed COVID-19 to create chaos, the level of chaos that it has created. So we look forward to a possibility of also the African Commission presenting its perspective in respect to the response to, as well as planning to a post-COVID socioeconomic order in Africa, in which Africa would be taking, as you rightly said, a leading role for a post-COVID-19 international order as well. Distinguished delegates of states parties to the African Charter on Human and People's Rights, representatives of NHRIs and civil society organizations, as well as colleagues from international organizations, my distinguished colleagues, members of the Commission. This brings us to the end of today's session, and indeed to the end of the public segment of the 66th Ordinary Session of the African Commission on Human and People's Rights. I would like to express my deep gratitude to each and every one of you for your dedication and for your active participation in the course of the conduct of the public session of the Commission for the past 12 days. I do hope and look forward to the consolidation of all the inputs that we have collected and received in the course of this session to enable us to articulate an agenda that would actually inform and shape a post-COVID socioeconomic and political order in Africa that is founded on and reflective of the commitment of the continent to a dignified and human-centered world. I look forward to see you all again when we have the concluding session that would also be the public session of the Commission. That will take place on the 7th of August 2020 at 9 GMT as usual, but we will also have a public notice on the website of the Commission on the program of that concluding public session of the 66th Ordinary Session of the Commission. Once again, to one and all, I thank you very much and wish you safe, to be safe and well in these very difficult times. I do hope that we will meet in person in a post-COVID environment. Thank you very much again. Have a good afternoon and a good evening.